Afternoon all. I'm just going to run through very briefly the decisions and some letters I've had from the CPS regarding the two sets of charges which they have now hijacked and dropped. Before I get into it, I just want to point out a couple of things. Number one, it's not a surprise, it's the Crown Prosecution Service. They're prosecuting on behalf of the Crown, not us. Secondly, regardless of the CPS's decision, the judge on my prima facie evidence actually issued the summons. He agreed that it at least needed to issue the summons. In one of these letters, any decision by the CPS does not imply any finding concerning guilt or criminal conduct. The Stephen Lawrence case, for example, the CPS didn't prosecute that. They had to take a private criminal prosecution, and we all know the results there, don't we? So, the first lot of charges against the director of Kensington Motor Company and one other who was there, dated 31st of May 2017. This is the letter where they dropped it. Now, just to go on, I have reviewed the case in accordance with the Code for Crown Prosecutors. When considering the case papers provided by the police, a prosecutor must apply the Code for Crown Prosecutors. Now, I'm not the police. In order for the case to proceed, I must be satisfied that there is sufficient evidence for there to be a realistic prospect of conviction. So, they've obviously applied the Crown Prosecution, the Code for Crown Prosecutors, and the prospect of conviction test. Now, I'm going to read briefly from, it's on the House of Commons website. It's a House of Commons library note SN/HA/5281. On page 3, there is no requirement for private prosecutions to satisfy the Code for Crown Prosecutors, which sets out the factors the Crown Prosecution Service, CPS, should consider when deciding whether to institute a public prosecution. So there is no requirement to satisfy the Code for Crown Prosecutors, and yet he reviewed the case in accordance with the Code for Crown Prosecutors. On pages 10 and 11 of the same document, however, the CPS does not apply the test in the same way as it does when it is deciding whether to institute a public prosecution. This is referring to private prosecutions, but they obviously have. It could not be right for the DPP, Department of Public Prosecutions, I believe, to apply across the board the same test, in particular the reasonable prospect of conviction test. I must be satisfied that there is sufficient evidence for there to be a realistic prospect of conviction. In considering whether to take over and discontinue a private prosecution, as the Code enjoins Crown Prosecutors to follow in deciding whether to institute or proceed with a prosecution themselves, the consequence would be that the DPP would stop a private prosecution merely on the grounds that the case is not one which he would himself proceed with. But that, in my judgment, would amount to an emasculation of Section 6.1 and itself be an unlawful policy. The very premise of Section 6.1 must be that some cases will go to trial which the DPP himself chooses not to prosecute. Just briefly, Section 6.1, that is from the Prosecution of Offences Act. That is the section which allows the likes of me and you to take a private criminal prosecution when the CPS can't be bothered. So, we'll run on to the decision now. This is still on the first case against two people. Something I'd like to point out, excuse me, it is not, in this case, it is not clear that the documents which are alleged to be false instruments are indeed invalid. Now, are they looking at the validity of the documents, or whether or not they are forged, false, and therefore criminal? To move on, this is why they dropped it. And this is related to the fraud cases, but the forgery charges were just the same. The Crown must therefore prove an element of dishonesty on the part of, as with the offences alleged under the Forgery Acts, that dishonesty is based upon the use of the false instruments as genuine. We therefore face the same evidential problem, namely that even if we could definitively prove the documents in question were false, don't forget 7 examples of his handwriting, 6 of them dated, 2 of them signed by the forger as well, which is far from definitive, and 2 deeds. We would have to prove that both were aware of that and then acted dishonestly in presenting them as genuine. As with the other offences, there is insufficient evidence to prove that either acted dishonestly. So we'll move on to that, whether they acted dishonestly and whether they knew. Now, I actually sent copies and informed Kensington at least 4 times, and the solicitors and the courts, and on at least 2 occasions I sent copies of the documents explaining everything and the handwriting and so on, and both versions of the same deed with Tipex etc. on to the director of Kensington Mortgage Company. I've got all the postage receipts etc. The CPS knew all this anyway. So, knowledge. First of all, section 12 of the Fraud Act 2006. Liability of company officers for offences by the company. It is an offence under this Act. Subsection 2 applies if an offence under this Act is committed by a body corporate, if the offence is proved to have been committed with the consent or connivance of a director, a manager, etc. Right, so I informed the director. Connivance. Basically, it means willingness to allow or be secretly involved in an immoral or illegal act. So just a willingness to allow. So we'll go from there. So section 12 allows for it not to have actually been their action, just a connivance will do. On the CPS's own website, under corporate prosecutions, it is important to prosecute not only the corporation, but those who are in control, like the directors. Certain types of offences, for example false accounting and regulatory offences, committed by a body corporate with the consent or connivance, there's that word again, of a director, a manager, a secretary of a company, makes those officers criminally liable. More on knowledge. Archbold, Criminal Pleading, Evidence and Practice, 1997, page 1521, paragraph 1749 states, there is some authority for the view that in criminal law, knowledge includes willfully shutting one's eyes to the truth. Now, there's various case laws on that. Don't forget, I send her all the documents, let her know. More. Halsbury's Statutes, Criminal Law, 4th edition, page 157. Knowledge includes the state of mind of a person who shuts his eyes to the obvious. Various case laws. More. Moreover, there is authority for saying that where a person deliberately refrains from making inquiries, the result of which he might not care to have, this constitutes, in law, actual knowledge of the facts in question. Various case laws. So I informed her, I sent copies of, including 2 deeds. There's no denying it on the deed. I've got both copies of it, for goodness sake. Knowledge is just shutting one's eyes, not bothering to check and allowing it to go on. Anyway, they bundled in the fraud by failing to disclose. I won't bore you with the details of why it was failing to disclose. They bundled that in there, but they've said that they can't prove whether the documents are false and whether or not they had knowledge. Well, there's the knowledge bit. What matter does it make whether the documents are false or not when there are charges for failing to disclose information? It makes no difference whatsoever. They could have been genuine, but if they fail to disclose them, then it's failing to disclose. Simple. They don't have to be false. Anyway, moving on, because